Welcome to today's program titled Russia's Invasion of Ukraine, Navigating the Business Challenges and Legal Implications, Session 3, Legal Excusability, Termination of Contracts based on the Ukraine conflict and Russia sanctions. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our moderator for today's program, Leon Rodriguez. Leon, please go ahead.
Okay, good afternoon. My name is Leon Rodriguez. I'm a partner in Seyfarth's Washington, D.C. office. And today we will be holding the third in our webinar series on implications for business of the Russian invasion of Ukraine. As we've discussed in prior iterations of this series, Russia's invasion of Ukraine has created new challenges for businesses. And what we're going to talk about today is the manner in which those challenges manifest a significant impact on commercial transactions and contracts throughout the world, including here inside the U.S. The war and the resulting sanctions and export controls imposed related to Russia and Belarus by the U.S. and other nations have caused supply chain disruptions, cost increases, and business continuity concerns. Today, we're going to give you a general overview. It's going to be a power-packed half hour on how international sanctions are imposed, the way to determine whether an activity or a company is subject to such sanctions, the way to confirm or secure a license to conduct business in a sanction-rich environment, penalties for violating sanctions and what to do if you happen to be on the receiving end of one, and how to handle scenarios where a company may be unable to procure goods or services, either because of the war itself or unable to perform its contracts because of the sanctions and export controls. So let's start with the basics. With me today are Gordon Peary, who is a partner in our LA office focused on crisis management, regulatory, and transactional matters. And from our Seattle office, our partner Andrew Escobar, who was a commercial litigator. So Gordon, we're going to start with you. Can you tell us generally about sanctions? Who imposes them, how long they exist, and just those nuts and bolts?
Sure, it's great to be here, and it is a very challenging but dynamic and exciting time, and wish everybody all the very best. Thanks for the program. So sanctions are imposed here in the States, and that the beginning of the sanctions story really begins in Congress or the president. And the text of the sanctions is, in appreciating the application of it, is a little bit like three-dimensional chess. You really have to look from different angles at the application of it, what happens when it applies, and then what you can do if you find that it does apply to you. So for businesses that are conducting and executing their business plan internationally, sanctions, you have to look at sort of the country or the list, whether it's individuals or entities or even vessels or airplanes, travel bans, and so forth. So up to this point, we've just shared what you already know. Really, the best thing that we can do for you is to give you practical guidance and steps for you to understand how to determine whether or not a sanctions applies to your company, and then really what to do about it. But again, it comes out of a number of different chessboards, if you will. Here in the States, I've told you where they come from. The Office of Foreign Assets Control, OFAC, actually is the one charged with the responsibility of enforcing or executing the sanctions. But you're really dealing with only one chessboard. You have to be mindful of the sanctions that are coming out of other jurisdictions where your company operates. And then that raises interesting questions as to whether or not a different country will sanction something, a person, an activity, or a behavior. And if that's not the case here in the States, really what must you do? So those are some of the questions in a kind of a high level overview, just to kick this off for you.
So my head's already spinning. So how do I know whether parts of my business might be subject to sanctions, either the U.S. or somewhere else in the world?
So let me get right to the practical punchline or the point. So many of these programs are purely academic. This one is designed to be practical. So the direct answer to your excellent question is there are, and we do this for our clients, we step into our clients' shoes and help the compliance departments do this, and we teach them how to do this in-house. But the reality is that there is a website. There's a website that actually is free and open to the public, and we can share this with you, where you can actually, in a series of fields, you can actually, if you have a question, you can describe the full name of the individual, the company, and it'll not only go through all of the Russia sanctions, it'll go through every sanctions program that's important in the United States of America. So there's a cottage industry where the same kind of thing is done, where you can do it on a private basis, and we have access to this, where you can punch in those same details in the information, and it'll not only run the search for any hits within the states, but also other jurisdictions, all in one fell swoop. So what'll happen is that there'll be a contract in your company's business, or there'll be an individual, or there'll be a means of conducting a market, a medium for conducting the business. So you can actually, in these fields, actually describe the your question, and it'll give you a range or a spectrum and the risk of proceeding with that contract, and then it'll actually detail what the sanction program is. Again, there's sanctions for individuals, specially designated nationals, sanctions for types of investments, sanctions for industries or sectors, and sanctions for countries. Your first step, and it's a practical step to take, is within your compliance department is to have access to these websites, conduct searches, and then I have contacts at Treasury where there are some questions, and we want to make sure that we get this right, because sanctions compels you to do two things. One is a negative thing, and the other is an affirmative thing. It compels you, once you have a hit, or you run your searches and you're finding that there's some question, and then you confirm that question with Treasury. Well, you have to do two things. The first thing is that you have to completely ban or avoid or restrict your company from doing that. But then there's an affirmative obligation that the law requires you to actually seize and hold assets after you found a sufficient hit. Now that's a mouthful. I'll pause there, but that's kind of the starting point again.
So Gordon, this is definitely a new area for me, but I imagine as with many other bodies of law, there are places where the government decides the sanctions shouldn't apply. Either the legislation does or the regs do. Can you give us some idea of the exceptions to the sanctions that may apply here?
Well, that's a critically important question. The short sort of Reader's Digest summary of the answer is that in addition to understanding sanctions, the application of sanctions, particularly to your company, you also simultaneously have to understand the carve-outs or the exceptions to sanctions. And in our space, we call it actually licenses. And so just this past week, there was, and you won't be able to see it as I hold it up, the Office of Foreign Assets Control and one of the chief directors within it issued a license authorizing the continued use of internet technology with essentially Russians and others. Again, and just to, if you'll indulge me, I'll just tell you what the license says. It basically says that it is permissible for U.S. persons wherever located to use internet services, software, hardware, technology instant to the exchange of communications over the internet But if you, again, with licenses and carve outs and exceptions, you have to read the fine print, because the license doesn't license you or permit you to actually conduct a sanctioned activity. It just says that in this case, we're not, basically OFAC is saying, we're not going to shut down the internet and completely wipe out all communication. That's what the license says. So it's just one example that I'm giving you of the need to understand that there are carve-outs to certain of these sanctions or certain sanction programs, and it's critically important that you understand that, sort of the bounds of the carve-out, and then where the, again, the prohibited activity starts. And by the way, if you, one last thought is that if you are subject to a block transaction and a bank or other intermediary has essentially frozen the transaction, that's not the end of the story. The last stage, or the final stage in this life cycle, has to do with actually getting permission and petitioning the government to get permission to complete a transaction. And sometimes those exceptions are made.
What happens? I can imagine it's easy for either companies to be unaware of the sanctions and violate them that way, or misinterpret the sanctions. What happens if you wake up one morning and in fact you discovered that you have?
Right.
Do you turn out the lights and quit? Do you turn yourself in? Like, what should companies do if that happens?
This one's an easy answer. Call us. Absolutely not. In fact, there are over 1,000 sanctions programs, lists, and the like within the United States alone. Think of the other jurisdictions and the other international fora that imposes sanctions, the UK, the EU, the United Nations, and so forth. What I'm saying here is that the way that you've posed the question is very important, because in fact, if you have a mental state where you are intentionally violating the sanctions, the penalties can be quite severe. 200, there are many examples and hundreds of examples that I have of this, but anyway, $20 million as a fee and 30 years in jail is, of course, the type of punishment that is given to the most egregious sanctions violators. All the way down in the sliding spectrum to people that, just like you said in your question, had absolutely no idea. Perhaps your compliance department doesn't include a daily check using that OFAC website that I referenced at the top. Somewhere in between, there is, and we assist these clients routinely, and there's yet another part of the sanctions program that we don't have a lot of time to get into, called CFIUS, the Committee on Foreign Investment in the United States, that we assist with as well. And but the bottom line is that they have, these offices within Treasury have actual teams that their only job is to scour the wire and the internet and even social media to look for transactions that have closed, that may have closed without permission or in violation of a sanction or an executive order or something even outside of the United States. So my point is that it's very important that you have upfront in your compliance program these various checks, access to websites where you can check, and then by all means, and again, there's a hotline at OFAC, but call us and we can assist with whatever you need.
So, Andrew, turning to you now, I think we started acknowledging that there have already been some pretty significant commercial consequences to the export controls and sanctions that apply as a result of the Russian invasion of Ukraine. What advice would you give to a company that has a commercial contract by it or its counterparty that in some way is affected by the invasion and the sanctions that have followed the invasion?
Certainly, and appreciate the question, Leon, and thank you, Gordon, as well for the overview on sanctions. So, company, you've identified an issue. Either you're unable to perform, or maybe your counterparty can't perform for a particular reason. Figure out what the reason is. Try, if you can. Is it a product of the war itself? Maybe you had a supplier in the Ukraine that cannot perform. and now you can't fulfill your orders with your end customers? Or is it a result of a sanction? Did you have a contract with a Russia-affiliated individual or company that now you can't, under the law, as Gordon explained, engage in that transaction? At least you're really worried about that. So first, identify what the problem is.
We lost Andrew. Gordon, you still there? Yeah, Gordon, can I ask you to unmute yourself? And while we wait for Andrew, maybe do you think you can share that website that you referenced?
Sure. Sure, I'd be happy to. So the best place to go is the Office of Foreign Assets Control. What we can do is, to the attendees that are participating in this event, we can actually send out the actual URL so that you can have access to it. And there are a couple providers in the market that can actually run these searches with not just US sanctions programs. So there are a couple URLs that, as kind of as a preview of coming attractions, we'll be able to share.
And let me ask you, are there particular industries or particular types of activities that we expect will be more profoundly affected by these sanctions than others?
Yeah, great question. So the short list of the hot industries include the financial services industry, energy and commodities, and one industry that maybe is not top of mind would be actually travel and luxury items. So just break that down just for a little bit. You've got all sorts of companies throughout the States that are exposed to price volatility in commodities markets. Sources of the commodities and the actual financing and the hedging for that. These are all things that we're keenly focused on, and we assist with financial products to help manage that. But those are the key industries, and we don't expect those key industries to change over time at all, Leon.
And I know we're going off script a bit here, but one of the things that that pretty much every day when you read the paper, you hear about sort of escalating sanctions, and of course, by all appearances, this invasion and its consequences are going to go on for a while. Are there things sort of not that haven't happened yet, but that seem like they may be around the corner? Sanctions we haven't already cited to that we could see happening either in the United States or elsewhere in the world?
Yes, we're probably in the sixth inning, if this were a baseball game, in terms of the duration of. We're maybe 2/3 of the way, I think, through the sanctions that, and we're by no means at the end of sanctions that could be exhausted for something like this. So the one that I think we should be keenly focused on is actually the financial system SWIFT. And perhaps, if you'd like to delve into that a little bit after we get back with Andrew, I'm happy to get to that.
All right. Can you hear me now?
Yep, we can hear you. We can see you. And not to worry, we were able to fill the time reasonably while you were away.
No, fair enough. Fair enough. Apparently, my internet provider didn't get that license that you talked about. With respect to doing engaging in internet transmissions with Russia. Sorry about that. So as I was starting to say, the first thing you need to do after identifying that you have an issue is to check the contract. What's the choice of law, and what are the contractual provisions? While there may be common law defenses that you have to deal with, your touchstone needs to be the contract in this language. Force majeure. That's the first clause that pops up in everybody's mind, I think, in these circumstances where you have war or embargoes, sanctions. So what's the scope of the clause? Does it have a provision relating to war, invasion, or hostilities? This would be relevant, I think, more so to companies based in Ukraine, or if you have a contract, that's connected to a Ukraine-specific business that cannot perform because of the war. If it relates more to Russia, then I think you want to look to the sanctions clause. And does the embargo or does the force majeure clause have language, as most do, that speak to embargoes, blockades, or sanctions? Then you call Gordon and just to double confirm to make sure that you do have a sanction issue. And we saw this in the pandemic as well. You know, as a lot of people know, the force majeure was a big issue in the pandemic and whether you could perform under your contracts. And so government orders, laws, regulations, or actions, your typical force majeure clause will have a provision along those lines. Sanctions would be a type of government order. So even if you don't have that specific sanction language, you can still fall back on that if you're looking to either excuse performance or deal with someone who is trying to excuse performance based on the clause. And then what right do you have? Is it a temporary relief from performance, or do you get a right to terminate under that force majeure clause if it is triggered? So that's the scope of the clause that you have to look at. Then you have to look at the requirements. All right. Well, was this a situation that was beyond my reasonable control or the other party's reasonable control? If you had something to do with it, then most courts will not let you enjoy the benefits of excusability under a force majeure provision. Courts also require foreseeability. Was this something that was foreseeable at the time of the contract? An example I would give is if you're entering into contracts now, the war in Ukraine and the sanctions against Russia are foreseeable. And so you are expected to contract with that in mind. But if it relates to a pre-existing contract, then I think you have more of a foreseeability argument. One could argue, again, given that the issues between Russia and Ukraine date back to 2014, you might have a foreseeability issue. And so you do need to keep that in mind because this has been brewing for 8 years. And so you may not be able to get that escape hatch. Proximate causation, that's something else too. Is the issue the proximate cause? Let's say Gordon has a company in the Ukraine. I engaged in business with this company, but separate and apart from the war, a fire broke out, unconnected to anything, and burned the warehouse down. Well, that wasn't triggered by the war itself. That had a different proximate cause, and so you just have to double check that too and make sure you have a good argument on proximate causation. And then you also want to look at the provision to see if it has a notice requirement. Some force majeure clauses require you, as the party seeking to exercise it, to give written notice to the other side. If you don't give notice, then you could run into issues with trying to exercise that clause. So again, look at the contract, look at the language, but it's not just force majeure clauses that are relevant for you. You also want to look at sanction-specific clauses, separate and apart from force majeure. A number of contracts, especially those dealing with international parties, will allow termination without liability if the subject of the contract becomes a matter of subject to sanctions or the individual on the other side. Or what you could do is also look at broader termination provisions. You have an issue arise, maybe you're not clear on whether you have that excusability argument, but the the clause allows for termination without cause on 30 days notice. So assess your rights, separate and apart from force majeure. What are the rights that you otherwise have to get out of the contract in any situation? Other termination provisions also allow termination if illegal conduct occurs or the subject matter becomes illegal. So a broader provision, but could be applicable. Changes in law clauses, those are relevant as well. Sometimes if there's a intervening change in law, the contracts may allow the parties to renegotiate some of the terms or to terminate outright, and that triggers the escape hatch, so to speak. And then lastly, pricing provisions. It's a lesser form of relief and may not allow you to terminate, but if there's situations arise that make the contract less commercially practicable, let's say the rise in oil and gas prices as a result, you have a trucking company, and now all of a sudden it's become exorbitantly expensive, and your price basis has increased considerably. If you have a pricing provision in your contract, you might find some relief there. Wouldn't let you out, but at least can soften the blow. So again, your touchstone here is the contract. Other provisions you might just want to keep in mind briefly: limitation of liability. Let's say you're unable to perform, the other side's accusing you of breach. Are you going to be liable for lost profits potentially, or have they been limited, right? So you want to look at your standard provisions. Liquidated damages, be aware of whether there's a liquidated damages clause that might come into play. or be available, and indemnity clauses as well. You do want to, when you're both looking to try to recoup and protect yourself or assess your exposure, you do want to consider the indemnification obligations as well.
So, Andrew, it occurs to me that the scenarios you've been describing until now are scenarios involving, well drafted and presumably well lawyered contracts. So what happens when you have a contract that either contains none of those clauses you just described, or in fact has language that runs in the other direction that really doesn't help a particular party? What needs to happen then?
Great question, and this is something we advised clients on during the pandemic, because we did find situations that either there was no force majeure or the force majeure was not the clearest, right? As long as there's not let's again go back to the contract. If there is a force majeure clause, you want to make sure it doesn't have a provision that makes it the only form of relief. As long as you have your common law defenses available, then there are doctrines in common law of impossibility, impracticability, or frustration of purpose. And so if the contract is no help to you, provided it doesn't have language that would prohibit you from asserting common law defenses, you want to look at whether these common law doctrines how strong they are within your particular state. Again, go back to your choice of law. If it's international law, then you're going to have to do a different assessment. But if it's under state law, the states do have varying degrees. Some are more permissive, some are stricter. All of these defenses, though, again, are almost pretty much every state will have a foreseeability aspect to it. A court is going to look at whether the issue that arose was foreseeable or otherwise could have been contemplated by the parties. And because many courts in many states construe these narrowly, you're really going to have a strong argument that this was not anticipated. One other thing you want to keep in mind, especially if we're dealing with the sale of international goods, is the Article 79 of the UN Convention on Contracts for the Sale of International Goods. This is relevant if you are based in the U.S., the U.S. is a party to the convention, and your counterparty is based in another country. Many countries are also party to this convention, so you want to check that. And as long as your contract does not exclude Article 79's application, then you do need to factor that in. But it gives an excuse of non-performance when you're dealing with the sale of international goods. So setting aside, it's not going to speak to real estate contracts or finance contracts, but if you're dealing with goods themselves, it's largely similar to the analysis you would do with frustration of purpose or impossibility. Given the timing, I'm not going to go into all that here. Just want to more so flag that convention. I think a lot of us in the U.S., when we're dealing more with domestic, we don't keep that in mind. And just be aware that is out there when you're dealing with the sale of goods.
All right, since we're a couple minutes from the bottom of the hour, let me just take a moment to read the continuing legal education code. That is S as in Seyfarth, S as in Shaw, 8439. Once again, SS 8439. And we do want to invite you to come back on Thursday for the fourth session in our webinar series, which is going to talk about the effect of U.S. sanctions versus Russia, specifically on commercial real estate documents. Gordon and Andrew, as we approach the bottom of the hour here, just want to give each of you the last word on what businesses can do to be prepared. Just sort of the top two things they need to keep in mind to be prepared as we move forward in this environment that's resulted from the Russian invasion of Ukraine.
Well, we would, again, thanks to everybody who turned out for this, but we would encourage the compliance departments at every international business venture to conduct searches. So as promised earlier, I wanted to just read off the URL for at least the American sanctions regime. And so it goes sanctions search, all one word, sanctions plural search dot OFAC, OFAC dot treas.gov. And again, we'll provide that URL if you'd like. Just get in touch with us and we'll email that to you so that you have it. But you've got to integrate that inventory, just like Andrew nicely said. inventory your contracts to see which jurisdiction applies. There's a sanctions program really for every jurisdiction. But that's a critical takeaway from since 2014 now, this latest round of war that I think a compliance department must have this as a part of their daily check. And again, we can work with contacts within Treasury where there are close cases. So before you block anything or restrict yourself from anything, make sure that you've got a direct hit. Anyway, thanks for the opportunity.
Thanks, Gordon. How about you, Andrew? Any last words for our listeners?
Sure. Just building on Gordon's point. Don't wait for the problem to rise. I know we have a lot of sophisticated clients here, probably have surveyed their contracts, but know all your contracts. So you're not just waiting to see, because this is an evolving landscape, I think, as Gordon touched on. And you want to anticipate not just the current problems, but what problems might arise down the road. And so having your contracts handy, knowing their provisions will be key.
All righty. Thank you both. And thank you all for attending today. And we look forward to seeing you again Thursday.